right, students, this is the video lecture for Chapter 11, which deals with intellectual property. Let's do this. The things that we're going to cover in this video lecture is primarily copyright, which is a term to denote it's a legal right for some type of intellectual creation. Okay, it's a legal right for some type of intellectual creation, and it allows the creator to monetize that work and basically make money off of it. The idea being that if we encourage writers and performers and musicians, etc., if we encourage them, then they will create beautiful, wonderful works of art, which they can monetize and have exclusive right to use for a couple of years or a certain period of time. And then eventually that work will go into what's called the public domain. When something enters the public domain, that means anyone can use it, anyone can borrow it, anyone can share from it. And it's supposed to make the world a richer and richer, better place to be. Now, that's the original intention. The way corporations have utilized and exploited copyright is that they keep extended the copyright. Disney is notorious for doing this, so that things created by Disney will almost never or essentially never go into the public domain. Okay. Now, a trademark is, let me look at my notes. A trademark denotes a word, name, or symbol or design used to identify a company's goods and distinguish them from similar products that other companies make. I'm not going to talk about trademark in this video lecture. Those of you who are interested in marketing or advertising can look at that section of the textbook. And here we have the Nike swoosh. That's an example of a trademark. And patents and copyright, there's a lot of similarity. They overlap. Patents refer primarily to inventions or innovations. And it's the same concept as copyright, that if you allow an inventor to make money off of their work, then they will create more products. The inventor can make money off the product, and then eventually everyone will make benefit of that product. But just as with copyright, corporations have found ways to exploit patents as well, so that if a company invents something even after 100 years, when theoretically that invention should go into the public domain, the corporation can find a way to keep controlling it. Now, one of the reasons why we're seeing more and more activity in this area is because new technologies are so complicated, and new technologies or a new invention like a new type of mobile communication device draws upon so many previous inventions that one person or one entity is no longer the creator. It's a group of people who've created things, and it relies on previous inventions. We're also seeing a rise in intellectual property cases because of basically remix culture. You know, I think you all know this. It's so simple to cut and paste and copy things, especially online. And, you know, I know there's a whole genre of TikTok videos where you take someone else's video and then you build off of it, or you duet with it, or you react to it. So the way digital technology is moving, it's just becoming harder and harder to distinguish what is truly a unique original creation and what is just blatant copying of someone else's work. This interplay between new technologies and copyright law has been going on, you know, for well over 100 years. Here we have an image of a player piano. This relates to a 1908 Supreme Court case. Okay, a player piano, for those of you who don't know, is an automated piano. That roll, it looks like a big paper towel roll right here, has paper in it, and the paper is cut with certain holes. And as that paper rotates, it trips certain mechanical, mechanical things, whatever. And it triggers something that plays the piano in a set sequence. And if you wanted to duplicate a song, you would cut a certain pattern into the holes. If you wanted to duplicate another song, you would cut a different set of patterns to the holes. And so basically you get a roll of paper, and that is a recording of the song in a weird way. That's like a recording of the song. Now, in 1908, the US Supreme Court said that a paper copy of a song did not violate copyright law. Now, it's not that the paper copy was not a copy of the song. What the courts were saying was, according to the way the copyright law was written at the time, again, this is 1908, According to the way the copyright law was written at the time, it did not cover something like a player piano, which mechanically reproduces a song. So this was an instance where technology had grown faster than the law, and the law has to play catch up, which goes on and on. It's sort of a never-ending dynamic. And then the Congress rewrote the Copyright Act to cover things like mechanical reproduction. What does a copyright protect? Original works fixed in any tangible medium of expression. The work could be published or unpublished, but as long as it's fixed in some sort of tangible form. Authorship includes composers, journalists, sculptors, even choreographers. Okay. The courts don't really define what they mean by original, but there must be some degree of creativity. Can't be too similar to something else. And the work must be capable of being seen or reproduced or communicated in some manner. An idea cannot be copyrighted, okay? You cannot get a copyright for an idea. However, the expression of that idea, right? Say I have an idea and the way I express it in writing, maybe that could have a copyright, but the idea itself cannot. And there are 8 different categories. They are all listed in the notes. Literary works, musical works, including the accompanying words, dramatic works, pantomimes, choreographic works. If I come up with a new TikTok dance for the latest Megan Thee Stallion song, if I did that, I could get a copyright on that. Pictorial or graphic works, sculptural works, motion pictures and audiovisual works, sound recordings, and architectural work. Okay. Now, when it comes to sound, there's this weird provision about stuff before 1972. The way the copyright law existed prior to 1972, those songs cannot be covered by copyright. The lyrics might be, but the music itself, stuff after 1972 can be covered by copyright. It's, all the stuff is so confusing. I mean, if you are interested and if you think you have the stomach for a law degree, I encourage you, because these things are so confusing. You could make a whole career trying to figure this stuff out. But a song recorded before 1972 that's remastered after 1972 is still not eligible. So again, these things are very confusing. And then design features and clothing can be covered by copyright. For a period of time, the Supreme Court thought that clothing was just purely utilitarian, but now design features can be covered by copyright. What does a copyright protect? Published and unpublished works. I think I mentioned that. Compilations. Now, if you have a compilation, say a compilation of songs, like on a mixtape, which are no longer really cassette tapes, right? But that's what they comes from, mixtape. The compilation itself could be covered by copyright, which I guess refers to the curation and arrangement of the songs. The individual songs may have their own copyright, but then the compilation itself could have a copyright. Ideas, history, and facts cannot be covered by copyright. What we mean by facts is like if something happens, it happens, right? If there's a fire, a natural disaster, the sinking of the Titanic, that happens. That's fact. People observe that. If I write a song about the sinking of the Titanic, my song could be covered. Or if I use video, do like a nice news package for a local news affiliate, that may have its own copyright, but the incident itself is not covered by copyright. And then here's some other things, finer points from the textbook. Individual points of interest and a GPS database could be covered, as well as HTML codes underlying a website. Words and phrases, okay, if they were created by the US government, they're not covered. Now, even words and phrases that are advertising slogans are not covered. Books and movie titles. The courts have said books and movie titles or song titles, there's just not enough to them to cover them by copyright. So you could have 2 movies with the exact same name or 2 books with the exact same name. Now, when it comes to work for hire, if you're working for some company, like you're working for a news station and you were hired, the employer, the person who paid you, the entity that paid you, will have the copyright. That is considered work for hire. Now, what constitutes someone being an employee? In this growth of the gig economy, that's a good question. Like, are you an employee or not? Are you a freelancer? How was the work done? Under what conditions was the work done? Who determined the days and hours that were worked? Was there a long-term relationship? All of these things are explored when the courts try and determine, was this actually work for hire or not? And if you are lucky enough, or let's say once you are lucky enough, not if you are lucky enough, once you are lucky and fortunate enough to have gainful employment in one of the media industries, if you're creating things, this may be a question to ask, like who's going to own the copyright? If I create things while I'm working for this company, does it stay with the company or could you take that with you? Good question to ask. Okay, what kind of control does copyright give you? If I create something, I have copyright. What does it give me? I have a right to reproduce the work. I can make derivative works. If I make a movie, write a book or something like that, I can make the sequels as well. I could distribute the work publicly. Now, when it comes to right to perform the work publicly and transmit, this relates to television. And the U.S. copyright law, or the U.S. Copyright Office has been involved with some interesting cases involving television. There's these provisions when you're watching, say, a major league sporting event, say, MLB or NFL owns the rights to this broadcast, blah, blah, blah. They mean that like you can't record it and show it in your home later or distribute it. Maybe you live in an apartment building and you somehow find a way to distribute the signal to everyone in the apartment building. You can't do that and then start charging people money. Like, hey, I recorded last night's Padres game, pay me to watch it. I mean, it sounds absurd, but no one would ever do that. But that's what that's related to. And there was a famous court case. I thought it was famous. I thought it was very interesting. I put the link in the lecture notes. This company called Aero, AEREO, I think it's spelled. They would capture over-the-air broadcast television signals, which are already existing over the air. They would capture those and then put that online, transfer that like through your home Wi-Fi to some device and give you DVR functionality for over-the-air broadcast television. Well, they were found guilty of copyright infringement because of this transmission clause, right? That they were transmitting a television broadcast that was covered by copyright and making money off of it. Now, I think that's so unusual because television signals are already over the airway traveling to you for free. But I guess Aero was not allowed to scoop them up and then resell them back to you through Wi-Fi. So that's what we refer to the transmission clause. You can't take some broadcast form of media, capture it, and then resell it or retransmit it to people. Okay, that's what transmission refers to. Okay, now we have this provision called fair use. And fair use is the most common defense when someone is sued for copyright infringement. Fair use is the most common defense that's used. What that means is that you can use a portion of some material that is otherwise covered by copyright for your own purposes. And the courts look at the purpose and character of the use. If you're taking something that was originally like a commercial television show or a film, and you're using it for non-commercial educational use, that's often considered okay. I think I'm covered by fair use. Whenever I use clips from TV shows or songs or something like that, I think I'm covered by fair use. But, everything is a case-by-case basis. The nature of the copyrighted work, if I take something that was, say, someone made there was a Lifetime biopic about a famous musician, a Lifetime biopic about Dolly Parton. We don't have a good biopic of Dolly Parton, right? Okay. If I took that and then used that, they might say, well, that's kind of okay because that's a real thing. And I could have presumably gotten the facts about Dolly Parton's life myself. So that's considered, that might be considered okay. Now the amount, that's a big issue. The amount, if I'm using a song, I want to sample a song to use in my own song, a couple of seconds, one or two notes, maybe that's considered okay. But copying the entire song is not considered okay. And then the courts also look at the economic impact of the use. Okay, the economic impact of the use. If my fair use of, say I take a clip from The Office, if my use of that destroys the syndication value for The Office reruns, then I can't claim fair use. Now, there's no way a 5-second clip from The Office used in a video lecture is going to destroy the syndication value of The Office. But just hypothetically, if your use of someone else's work destroys their economic market or makes it impossible for them to generate revenue, then that's a problem. But these are kind of the provisions and some of the criteria that a court would look at to try and determine if using someone else's artistic work can be justified under fair use. I'm going to go over a couple of famous cases that deal with fair use. First case I want to talk about is this band, 2 Live Crew, a rap group. They were known for rather vulgar, rather risque lyrics. One of their hit songs was Me So Horny. At the beginning of this video lecture, I used a little sample of Me So Horny, and hopefully the YouTube copyright police won't yank down this video because I'm using it for educational purposes. Now, here's a cover of one of their albums, As Nasty As They Want to Be. I've covered up part of the cover. Those women are wearing bikinis, but they're pretty skimpy bikinis. I think you can probably imagine what it looks like underneath that words there. They did a cover of the Roy Orbison song, Pretty Woman. Or at least they use the riff. There's a very, very famous guitar riff. And I know you've heard it. Even if you didn't know it was a Roy Orbison song, I know you've heard it. Among other things, it's featured in the last version of A Star Is Born. Bradley Cooper is on stage. I think he's drinking at that point. Bradley Cooper plays this song. Very famous guitar riff. Anyway, 2 Live Crew cover it, or they use the riff, and it's quite clearly Pretty Woman. I mean, it's like anyone who knows music are like, oh, that's Pretty Woman. Roy Orbison's estate sues, said they shouldn't have been using, they were using an unlicensed, unauthorized use of the guitar riff. 2 Live Crew was claiming fair use, and then the judge said, well, it's a parody. It is a parody, and a parody of something, meaning you're spoofing it, imitating it, mocking it, is okay, which is why Saturday Night Live and other comedy programs can get away with copying things, because it's clearly a copy for comedic purposes, and no one in their right mind would mistake, I mean, if SNL does a version of the new Avatar movie, no one in their right mind is going to mistake one for the other. So I thought that was kind of a weird workaround when they said, oh, it's not a copy of Pretty Woman, it's a parody of Pretty Woman. Now, this did not trigger a lawsuit, but I remember when this movie came out and everyone thought it was going to trigger a lawsuit. The movie's called Escape from Tomorrow. A filmmaker and a crew go into Disney World. That's the thing in Florida. I always get Disney World and Disneyland mixed up. I do. People from Southern California are obsessed with Disney. It's like a cult. And I didn't grow up in Southern California, so I don't understand this weird obsession with Disney. I'm sorry if you are a Disney fan, but I think it's weird. Anyway, the filmmaker goes into Disney World with actors. They sneak in video cameras to make it look like home video cameras. They shoot an entire movie inside Disney World. And it's this bleak, sort of depressing, weird, psychedelic, trippy movie. And they shoot the whole thing inside Disney World. And when it came out, everyone said, oh my God, Disney is quite litigious. They're known for being very litigious. Disney's going to sue the hell out of this guy. Disney and the Disney lawyers ultimately decided not to, probably because they knew that attacking the film would just generate unbelievable publicity. It was a very, very low budget kind of art film. So they didn't sue. All right, now here's another one. This gets back to this whole concept of parody. Gone with the Wind is one of the most famous books in American history. The film Gone with the Wind is the most successful film of all time, at least in the United States. When you adjust for inflation, Gone with the Wind has made more money than anything else by far, more than any of the Marvel movies, more than any of the Star Wars movies, adjusted for inflation. Okay. The story of Gone with the Wind is a very romantic story about the Civil War, and it paints this positive portrayal of life in the old South, right? When people lived on plantations and life was so wonderful and genteel and romantic, according to the book. Okay. Not my words, according to the book. Well, times have changed and not everyone has the same romantic, positive nostalgia for the old South. Okay. Some people have much, much different feelings. So Alice Randall, I think this is a great, great idea for a book. I never read it, but it's a great idea for a book. Alice Randall retells the story of Gone with the Wind, but from the perspective of a slave who's living on the plantation. The title of the book is The Wind Done Gone. I think this is perfectly justified. I think this would be perfectly justified. Margaret Mitchell's estate, Margaret Mitchell was the woman who wrote Gone with the Wind. Her estate sues, and the only way this book, The Wind Done Gone, was allowed to remain on the market was they called it an unauthorized parody. They literally put a sticker on the book that says, oh, it's a parody. It's not a parody. It's just sort of an alternate version of that story. But that's a way they got out of it. And there maybe was some sort of out-of-court settlement as well. Okay, I talked about new technologies causing problem for copyright law. Here's an update, at least on sort of the semi-current situation. There's something called the DMCA Safe Harbor Practice. That's Digital Millennium Copyright Act. The provision here, kind of like Section 230, which we talked about, this shields ISPs from infringement claims. Basically, if I, just back to The Office, if I record a huge chunk of The Office and put it up on YouTube, I'm guilty of a copyright infringement. YouTube is not guilty. I'm guilty, okay? And the courts have said that if YouTube has a policy about removing copyrighted material once they receive a takedown notice, if like NBC Universal or whoever owns the copyright to The Office, if they contact YouTube and say, take down this video, if YouTube complies as soon as they get the takedown notice, they're totally fine. They're totally fine. And the courts have also said if I posted a video that, say, has a chunk of The Office, YouTube takes it down, and then I'm later able to successfully argue that, oh, my use of this Michael Scott press conference, he's a character from The Office, my use of this clip was not actually copyright infringement. I, as the creator of the video, cannot then go sue or complain to YouTube like, hey, you mean internet people, you took down my video unfairly. That, you know, YouTube basically is kind of removed from punishment or penalty in this case. That's what we refer to as the safe harbor. Now, some of the, again, you know, there's ambiguity and nuances to everything. There's something called red flag knowledge, which basically says that if someone posts a video that is clearly copyright infringement, like there's no question about it, in that case, the ISP or the, you know, social media platform could be held responsible. For example, if I got a copy of She-Hulk, whatever, the She-Hulk series, if I uploaded, you know, every episode to my personal YouTube channel, that's clear. I mean, you know, that's plain as day. That's, you know, that would be a red flag. Also, these DMC safe harbor practices cover state copyright laws as well. You know, not just the federal copyright laws. And then finally, YouTube, back to YouTube, they could be held responsible if they have a policy about removing infringing material and they're not enforcing it. Like if they have a policy that says we're going to take down stuff once we get a takedown notice, and they don't actually do it, then in that case, that could be something wrong. All right. Well, again, I know that there's a lot of nuance and ambiguity to stuff, and I'm not a lawyer, so I explained it to the best of my ability. All right. That's it.